time ago to say, all right, I don't like the way we said that.
Yeah.
Okay.
Yeah.
And then did we go to a lawyer to have it all changed, or did we just let them know that we, or how did we?
Jay Bremyer, J.D., was licensed and practiced law in Kansas for 20 years before retiring in 1990 to write The Dance of Created Lights and The Chemical Cook. Additionally, Jay has written widely on subjects including children in need of care, as well as general social, political, and legal issues. He has been the subject of TV and radio interviews and facilitated workshops on community building, wills and trusts, death and dying, alternative dispute resolution, personal empowerment, and contemporary culture. Yes, Your Empowerment Solutions, YES, in Crestone, Colorado, founded by Director Judy Rose and Sophia Balikian, is a networking and organization building service funded by Saguache County, Colorado, to engage and empower community members with matching needs, skills, and resources. Judy and many of her presenters and helpers volunteer their time to help Crestone be a model of successful cooperation for the world.
I'm Jay Bremyer, and I'm really pleased to be here and thank Judy for all the work that she does in organizing this sort of thing. Well, a little background about me first. I started practicing law like in 1971, practiced for 20 years in central Kansas, general small town practice, which is a lot like being a doctor in Gunsmoke. Whatever people need, you just do. And that was the kind of law that was good for me. I had been, Sarah and I, my wife, had been involved in small literary press and doing writing. And when she got pregnant, I realized I needed to have a gig that would pay. And so my dad was a lawyer, and he said, why don't you be a lawyer? And it sounded good, and I really enjoyed it. But 20 years later, I stopped practicing to take a 6-month sabbatical to write a book on children in need of care, because I was doing a whole lot of adoption work and work with foster care, and children are at great risk. And by the time I was kind of through with editing that or working on it, and an editor had it, I started on another book, and it's been 25 years, and they don't longer have my name on the firm letterhead. And about 5 years after that, I stopped going to continuing legal ed, and I dropped my license, and so I literally am not a lawyer. I'm trained as a lawyer. What I can do is tell you about my personal experience. I can try and familiarize you with the vocabulary, because I do have that advantage. I spoke legalese for a long time. Everything that I'm planned to go over, you can really find on the internet. Since I stopped practicing law, I discovered as I started representing myself, and everybody has the right to represent themselves. You can't represent somebody else. That's a violation of the law. That's why I can't represent anybody here. But you can do your own work. And then what I would suggest, after you conceptualize how you want to do, and I'm calling this wills, trusts, and beyond, if you figure out kind of what you want to do, dialogue with your friends, your significant others, talk to me, whatever you want to do in terms of conceptualizing, then before you finalize it, if it's something important, it's good to run it by a lawyer or run it by a tax person or get some professional advice. But I think what we're all about here is figuring out how we can be self-empowered. We don't have to rely on outside sources. We've got enough resources in our own community to do most things. And there's a service on the internet called Rocket Lawyer that I looked up because we needed to do some deeds for ourselves. And you can sign up for 2 weeks free. And then if you cancel within in 2 weeks, everything you downloaded, wills, trusts, powers of attorneys, all that stuff, is yours to keep. And they keep an archive for you because they think you'll get hooked and sign up to pay the annual or the monthly fee, which is also rather modest. So it was a great resource. And I also discovered, since the time that I practiced law, lawyers have not stopped charging huge amounts. I mean, it seems like everybody charges a huge amount. And it's scary. You don't want to go into a lawyer if you don't know really what you want and this is a lawyer that you want to talk to. Or an attorney. It's both words mean the same thing, but a licensed lawyer who will represent you. But in addition to that, you can go to this. When I was practicing law, you had to spend a lot of money to have a big library, and you had all kinds of expenses. But today, a lawyer doesn't really need that much, nor do you, because you can go to the Secretary of State's office in Colorado, or the corporate office, or any office, any questions. If you just Google them, if they're legal questions, they'll come up with a source that'll give you statutes and regulations and the continuing Colorado's, there's a service in Colorado that actually has explanations. There are a lot of services that refer you to lawyers. So there's all kinds of things you can do yourself. So that's a little bit of the background. As I was thinking yesterday afternoon, what are we going to talk about? Well, I want to talk about what you want to talk about. I want you to tell me what your level of interest is, what the terms that you're wondering what they mean, and help me know where to go with this. But I was also thinking, well, when we came out here in 2000, during 2000 we built a place, and 2001 early we moved in. Didn't I write some poems called Mad Lawyer Poems? So I did a search on the internet, and I mean on my computer, and there it was, Mad Lawyer Poems, April 7th and 8th, 2001. And it wasn't mad like angry, it was mad, I hope, like crazy good mad, you know, but trying, we're all in transition. We all have part of us that's still living in, you know, our earlier lives. Almost all of us are new transplants to Crestone, to these sacred mountains. And, or at most, our parents lived here and we got to grow up here. But most of us are new here. And so we're forming a new community and we're tying into what are these spiritual resources that are available. But we also have the practical issues of our kids are in trouble, or what if I die or I get disabled, and who's going to take care of them, and what happens if I do nothing. And those are the things that we still have kind of from our former lives, things that we learned when we were younger. But maybe we don't quite know what they are. So the first one was called reincarnation. And it means, I'm sure I'm struggling to figure out how to be born again without dying first. Last time I visited the Mad Lawyer, he was writing about the antics of his younger years and making lists. He was of two worlds, already gone from that one, still very much of this world, and still very much of that as well. He was plowing, making ready for the new seed he was planting in his body. Something about the fertile imagination. He raved that back in the before world, he would become alive again and work some deals, which would be good, he thought, for his family. Consensus. It had nothing to do with mad cow disease. He was just a lawyer and patently crazy from some points of view, angry and courageous in a way, upset with his shortcomings, determined to make sense of the world, which we're all trying to do. When he was in the mountains, the Mad Lawyer loved to get up in the mornings and sit in front of the big windows scribbling poems about agrarian idealists, cosmic utopias, Anglo-Indian cognates, etymological derivatives, eagle feathers, adobe hermitages, mother temples, Zen, Spanish, love of death, then walk into the pinyons and sit on the flat stones. Morning. It is more than lifting of shadow. Sun rises over mountain. Whole world smiles. We're really blessed to be here. And I'm blessed to ask you to ask me to dig back into my past and see if we can anchor some of the things that relate to wills and trusts, powers of attorney, and those instruments that we can create to guide ourselves and our loved ones through the chaos of change. And by drafting and developing instruments like wills, trusts, and understanding the context in which they'll be implemented, we can do a lot to limit the expense and the damage that can otherwise be done. So, well, unless you ask me, I'll just start with kind of do an overview, and then a lot of this is sort of new, or you have ideas that maybe what Jay said isn't what I thought, and so then at some point just don't worry, just stop me and we'll go back over it. Yes?
I think a place to start would be, what would happen if you did nothing?
That's my first time. That's exactly what I was going to say. That's a great way to start. I guess we can't stop yet. All right. What happens if we do nothing? Well, let's say you get really sick and your people around you can no longer take care of you. And these are the things you don't want to have happen. I mean, we all at some point can get sick, but we don't want to not have planned for what should happen then. And because if the law has to take care of it, they'll set up a conservatorship and a guardianship. A conservatorship takes care of your property, pays your bills. Guardianship takes care of your personal life, hospitalization, anything like that. The difficulty is both of those are court supervised. They're not necessarily the people that you want to have taking care of you or making those decisions. You've got legal fees, you've got accounting fees, and fortunately, it's very seldom it actually happens because most of us are able to band together as a community. But if you do nothing, that's what happens there. What I suggest you do instead is have what's called a durable power of attorney. It's one of the simplest things you can do. You can print them off the internet. You can go to any hospital. You can go to most end-of-life organizations. Anything like that will have examples, and there are a lot of different kinds of them. I have a file here where I just ran off different ones, which I'll leave afterwards, and people can pick them up. If you get down to there's only one left, Judy said that she'll be willing to copy them for you. I also have my cards here that will give you my email address and phone number so you can call me. And I'm happy to do it just as long as people know. I mean, it's just like we run into somebody in the post office and you have a sore shoulder, they'll start rubbing it. If you have a question, I'm happy to talk to you just as long as we're doing it as neighbors and friends. And because I haven't charged anybody a penny for anything since I stopped practicing law as far as this sort of thing. And it's wonderful to be free of that. That's the worst thing about being a lawyer. I mean, it really is awful. Most people who became lawyers that I knew in the 60s was because we had our friends were going to jail for protesting or whatever. We wanted to try and help people. But then you ended up with your debt and your pressure and your overhead and your senior partners, and it gets very hard to do what we're doing today, which is just visiting, although I did as much Robin Hood as I could. I represented big banks, and then I did the kid stuff for free. So you can just pick these up, or Judy or somebody will tell you how to get a hold of me. A power of attorney is where you pick somebody, and obviously you want to think, well, who would I trust to do this, and you want to talk to them about it, and you want to have some alternatives. And it can be your spouse, your significant other, your partner, it can be your best friend, your brother. You generally want to have somebody whose health makes it so that they're likely to live longer than you. But you can have somebody, your parents, and then if they're not available. And you basically say, if I become unable to do things for myself, I give them authority as my attorney in fact to do it for me. They're my agent. And if you see this document or a photocopy of this document, you can rely on the fact that they have authority to write checks for me, to check me into the hospital, to visit me in the hospital, and you can have them that are 15 pages long, or I often have one that's just 1 page long that's for signing tax returns if I'm not in town, or anything that's a backup. So our kids have them for Sarah and me if something happens. So they can get into our lockbox. Those are called powers of attorney, and they're called durable because you want them to remain intact through the time that you're disabled. If you do nothing and you become disabled, it's too late. You do nothing and you die, we'll talk about that. It's too late to do your planning. And so it's durable in the sense that you create it while you're capable and legally competent, and it will endure through the beginning of your incapacity. And it says things in it like, if I file a notice with a county seat in the county of my residence, and they have to be notarized so you know what the county is, saying this has been revoked, then you can't rely on it. And I don't want to go too far because these things get complex, but the thing is that people worry, well, if I do that, then what? They've got authority over me. If you're still competent, you can always withdraw it, is what I'm saying. There are ways to say, no, I don't trust that person anymore. There's also a good thing. I mean, we are so blessed with what's the organic common law started in England, Anglo-Saxon, way back, Greek times. All this development in our particular legal system that has, it has the law, which are the statutes, the written decisions, and then it has the equity, which is ultimately courts have the ability, and we're blessed with a lot of good judges, we really are, who can step in and kind of override the law in certain circumstances. And one of them is that you basically have made a contract with this other person. They're going to be your agent. They're going to be your attorney in fact. But what if they relapse and have a terrible meth habit? Or they what if something happens? And I've been involved when things like that. How do you stop? And you become disabled in the meantime. Well, the courts always have authority. Some friend of yours, somebody will say something's going on. You can apply to the court to review that. And the court can eliminate that person that you trusted, and for good reason, but the circumstances have changed. And the court will then try and appoint, depending on the language in your power of attorney, but appoint somebody new or set up a conservatorship or do something to straighten that out. That's generally the backdrop. Courts actually can step in and change things. We're all concerned when we have minor dependent children or adult dependent children about a guardian for them, setting up a guardian. And generally you do that in your will, but you can actually make arrangements by contract in a way, or at least written designations of who you believe, so the court would know who you wanted to have appointed. And it's the same sort of thing. You appointed your sister Mary. She was great, but things have changed and she's no longer would be the proper one. Any family member, anybody interested can apply to the court and say, I think that needs to be reviewed. Obviously, you never do that sort of thing lightly, but I'm saying in a circumstance where you really have concerns, there are measures that can help correct something that you thought would work but isn't working. In addition to your powers of attorney to do business for me and pay my bills and make medical decisions for me, you often have a couple different powers of attorney, one that's for medical and one that's for business and finances. There are also things called declarations against heroic measures. They have different names, but a lot of people now, as they're doing end-of-life planning, are really trying to come to grips with what do they want, how do they want to die with dignity, or is their belief that you should do everything possible no matter the expense. And that's a personal decision.
Give the name of that document.
I call them, and there are also examples in here, I made a lot of those, but declarations, you're making a declaration against heroic measures. And what that means is, in our medical system now, with our great technological abilities and the doctors having protocols that tell them they have to do everything to sustain life no matter what, doctors have great pressure on them to go to whatever extent heroic is possible to save one person. And we can talk all day about is that a good allocation of money, but it is the system here. So if you have, it's really important, instead of doing nothing, to actually think about what do you want to have happen. You're in a wreck, you're disabled, you develop catastrophic cancer without any recognition it's coming on. Things happen and you haven't thought about it, and it can be too late. So just stop at your local hospital. They'll give you their form that they like to use, a declaration against heroic measures, or it might be named something else, but that's what it is. And then you go through there, and it says things, you have options as to how to word it. I think in ours it says something like, if my treating physician and one other qualified physician says there's no reasonable opportunity that I will regain meaningful life, I want you to stop doing heroic measures. I want you to let me die in dignity. And, well, yes, please. It's great. It's really great. Everybody should ask.
So many of us have filled out the 5 wishes.
Perfect.
Does that hold, in other words, would that take the place of having to get another document?
Sarah had me run off her copy of the 5 wishes, and I haven't studied them the way she has, but my understanding is that they're really good to have, not only in terms of preparing yourself, but a great deal of relief to your family and your caregivers. They're wonderful.
And in terms of actually holding them, so that there isn't, heroic
measures
that are taken against your desire, is that a document, do you know, that will actually stand?
I think that,
Speak up, darling.
I think if you have a notary public sign it in your presence, I think that makes it valid. I'm not
Yes.
positive,
Yes,
I'm
it
not a
does.
lawyer, but
I'm with the custodian of life, and that's what we're using, that document.
Right.
As a declaration against heroic measures.
Right.
Or heroic measures if you choose.
It has.
You have a choice.
Yeah, that's right.
And it stands in court.
that's my
It's a
understanding.
national.
Is that the same as a DNR? Because on our file of life that we give out to people, it says you have a DNR.
A DNR.
Not resuscitate.
Yeah, those are all parts of the different variations within the documents. On the 5 wishes, and I wanted to mention, because I talked to Anna Louise about this the other day, she thought she might be able to be here, who also works with you on the end of life. Our good friend, Trudy James, who was here for a couple years ago for a month, and she will no doubt come next year or the year after, is really one of the leading people in the country on end of life, and works out of Seattle. So I have some information on Trudy in here that she sent, ethical wills, her email address, her website. They're making a movie about her now, which is this series of classes that she does over 5 weeks, where people really work with all the things on the end of life and on the 5 wishes material. And they've done some YouTube kind of videos of people who've had these extraordinary experiences, often discovering that their kids are dead set against what they want. Their kids have no idea what they want, and there's these huge family issues. And it's just a revelation to look at the work that Trudy does when people come for the first time to speak honestly and deeply to their children, to their disaffected in-laws, or whoever it might be, but finishing up. And you don't wait till you're dying. You do this now. Because we're all dying a little bit every day. We're all being reborn a little bit every day. And this is building your life at the same time you're preparing for the ultimate death transition. So Trudy's just great and wants to work with the End of Life Project, which is the premier and most wonderful thing that's ever happened, as are the green burials and the other things that we have here in our community. So I agree with Sarah. You can be completely innocent, somebody can still sue you. You can be completely right, and somebody may refuse to do. But the more things you overlap of what you want, the much better chance that it's going to happen that way. And Trudy also works a lot with the Hemlock Society and voluntary death, which is quite amazing, how you learn to stop eating and drinking and move yourself forward in a way where actually it's no longer up to them because you're in charge. Most of what we're talking about here today is how to be self-empowered. Jen?
I want to go back to durable power of attorney. Can you set up like a something sequential in that, say if my husband's my durable power of attorney, and if he suddenly is gone, can I set it up so that there's somebody next online?
Absolutely, and I really think you should. really, and 2 or 3. And all of your documents like this, all your instruments, should be reviewed periodically to see, well, what's changed? Is it really still, is Ed still available? Is John still available, or Margaret? Or have they moved away, where it would be an impossible complication for them to try and help in that circumstance? Yeah.
I'm guessing durable power of attorney is more powerful than, like, if I didn't have that, would it automatically go to next of kin, or?
To be appointed, you mean?
Yeah, or does that totally go to the court?
It goes to the court, in my experience. That's the reason you want to do these things, because if it falls back on the court, they may do a great job of picking somebody. They'll certainly want to. And it's much easier in a town like Alamosa or Saguache, where there's not so busy. But you're in a city, you're lost. You may not get a court's attention for months, and you can even be that way here. So do these things. Yes, Judy?
When Dennis and I first moved here, we went to the court and filled out, I don't remember what it was, something about our property and everything else. So we have to go back to the county and retrieve it?
Is it something you filled out that was about your, what to do if something...
With the property and how it's divided and things like that.
Well, I would go and see what it is, get a copy of it, and then we'll look at it and read it and see if it makes sense.
Because I just remember that we did that 15 years ago.
And that's why I said I practice law. I never practiced in Colorado, so what I know is only what I chose to look up on the internet. There may be things there that I don't know about. But anything you've got out there that's dangling that you're uncertain about, retrieve it, read it, and if it's not right, then revoke it, and there'll be a way to revoke it or destroy it.
I just wanted to let people know, Crestone End of Life Project has now a new, we saw there was a need in the community as well as the world about informing people about these kinds of issues, and we're in the process of, we have a Annenberg grant that to put together what we're calling informed final choices, and it's educational outreach that we're going to be doing starting very soon, and then going forward on different aspects of durable power of attorney, what do you do with people that are, how you can help people, support people that are grieving, green burial, death cafes, all kinds of aspects around this issue of end of life issues.
Yeah,
so
that's beautiful.
Look for us soon. We'll be doing a new another death cafe pretty soon.
Great.
This fall.
Did everybody hear that in terms of the end of life is really spreading out and taking the material to the larger community and adding new things to it, and going to have another death cafe, which of course are wonderful opportunities going around the world to sit down and talk about end-of-life issues. Yes?
Yeah, one of the questions I have is, I lived in California for many years, so I have a will from California. Does that work in Colorado?
The question is whether if you have a will from other states, does it work in Colorado? I looked it up on the internet, and it's consistent with, it has to make sense, that wills from any state done under the laws of that state are recognized and will be implemented in the state of your death. That's not a concern. The concern is make sure it was done in a way that was proper under the laws of the state, because they require things like certain types of notarizations, witnesses, so every state's slightly different. But as I said, you can go on to this Rocket Lawyer site, and there's like about 10 of them, and print off a will that complies with Colorado law. And it will show you, and at least gives you something to start working with in terms of these are the things that I ought to check and think about. So I want to get back to the first question. What happens if I do nothing? So we've already talked in a kind of a general way about if you have a durable power of attorney, that's going to do a lot to take care of things for you in terms of somebody having authority to make decisions, right? Pay your bills, keeping your home, all the things that you want. And of course, with that person, you want to, I always recommend write a letter too. You don't have to deliver it to them right then, but it's a good idea to go over it with them. But you want to have as much instruction to that person and to your kids, or it might be your kids that you're appointing, of what you want. I think that you just greatly simplify it for the people you care about if you tell them what you want. and you tell them in such a way that they know you've seriously thought about it, you've done your work. And so if you do nothing and then you die suddenly or whatever, and don't have a will, your property will be administered by the probate court by intestate succession. Intestate succession just means you didn't have a testament. You didn't tell people what you wanted. So the court has to fall back on its general rules. And I assure you, in many, many cases, those general rules are not going to be what you really wanted. And they're complicated. Generally, if you have a surviving spouse, they will, with no children of either of you, they'll get it. But what if you have a partner, or what if you're in a state that doesn't recognize gay marriages, and this person is the most important person in your life? Do you really want it going back up to your parents, which is what would happen? And if your parents are dead, it go over to your brothers and sisters who may not care at all. They may be anti your loved one. So you don't really want to fall back on intestate succession. We can go into what would other things that happen. Basically, if you have a wife or a husband and children with him or her, the children get half and the spouse gets half. But if you have children by a former marriage, which most people do these days, then there are ways of allocating that. And the examples at the Colorado's continuing education site were way too complex for me to try and comprehend and tell you about, because none of us really want that sort of thing to happen. We want to decide who gets it. And lots of times you have a kid that's not any relationship to you, but they're your kid. That's who you want treated equally, or you have kids that you want to cut out. If you have a will, you can't cut out a kid that's dependent on you. But you can cut out a spouse if you're disaffected. And if you're disaffected, if you don't like them, if you've not lived with them, if they're whatever, you don't want them getting half of what you had for your kid. So you want to have a will, and you want to talk to whoever your spouse is, and you really want to have them plan with you. So if that spouse agrees to your will, signs consenting to it, then your will be implemented, and his will be implemented because you agreed to it. And so you can fine-tune it that way without over-complicating the discussion.
So if, this happened to two of my friends, they were named in a will, and maybe their sibling wasn't named, and yet they were taken to court because the sibling who wasn't named said they should be receiving part of that money. Mm-hmm. And it's now 7 years later, and it's still in
litigation. Yeah.
Oh yeah. So do you have to actually exclude someone that you don't want to have?
It's better to. I think the law may even provide that you should. I always do recommend that. I want Betty and Jill to have one half each, and I have another child, Margaret, and she's not to receive anything. That's enforceable almost any place in my experience. If you don't say, then there's always the question, was it clerical error? And it should take 7 years to resolve something, but that's the reason you want to make sure that you work it out with the people and you be very explicit as to what you want. Now, we've had situations in our family where people have died without a will, and we wanted the surviving spouse to have everything. The kids knew that she needed it, and so all the kids just disclaim succession under intestate succession as if they had died before the parent. And so it went automatically to the surviving mother. So with help, you can fix a lot of things. A broken arm, okay, we can fix it. But you kind of have to know what you're doing, and you're better to not have to fix. Don't fall out of the tree. Jan?
So in a community property state, is half of my estate, including my home and everything, is half of that mine and half of my husband's? So if I want to make sure that he gets the whole thing, I need to spell that out.
I think so. I don't think we're a community property state, are we? Is Colorado? Western, I know California and a lot of states are, and Colorado may be somewhat of a hybrid. Well, that's a good question for all of us. And literally, just Google, is Colorado a community property state? And then if it says yes, then there'll be different, on search engines, different explanations of what that means. I never even thought of that since we are still legally Kansas residents, so we haven't needed to think about that personally. It's a good question. Yes?
Is it okay to have a durable power of attorney living far away from you?
It is.
In another state?
Yeah, if the agent or the attorney, in fact, that you appoint under your durable power of attorney is far away, it can make it more awkward. But if it's a person that you believe you want to have appointed and you've talked to them, there's no reason not to. And a lot of things can be done remotely anyway, as far as finances. You could have two that jointly operate, and we're going to talk about trusts as well, which is where you can get a lot more elaborate with a lot more options than you can with just a straightforward, durable power of attorney. But I want to, well, we've been talking about intestate, which is you die without a will, which can be really difficult, versus testate, which is where you have a will. In just general conversation, I realize that most people think that having a will avoids probate. And in fact, a will is no good unless you probate it. It's just the reverse. A trust, you don't have to probate. And a trust is what we're going to talk about to save the money of probate. But a will is very important because it's simple to do. If you have any property that's remaining that hasn't been otherwise disposed of, the only way to get it to who you want it to go to is to have a will. So even though you might decide that you really want to do a trust, I would still want you to have a will, because people forget that things can happen. You can be in a... Lawyers have these dreadful imaginations. Nobody... I know I'm not a lawyer. But you can be in a wreck. I've had this happen. You're dead. You have everything set up, you think, in your trust. I haven't had exactly this happen. I've imagined this. Then your lawsuit for wrongful death, and here's $100,000 or something that has to go under intestate succession through a probate procedure without a will delivered to the wrong people. You're gone. Your kids need your money, and it just gets into that complicated thing where it doesn't go the way you want it to. So a good, simple will is always a backstop to make sure that you have taken care of things that you haven't otherwise disposed of. How do you otherwise dispose of things other than a trust? All kinds of ways. Joint tenancy, payable on death, Darlene? Beneficiaries, absolutely. You're a beneficiary on your insurance policies or on your retirement plans. All those types of properties have ways to show who it's going to go to. And of course, if you have that, or a contract for deed that becomes effective upon your death, there are all kinds of things to transfer your property that avoid probate and don't need a will and don't need a trust. There are also some problems with some of those things that you need to think about that most people haven't. And one thing is like putting your kids on your checking account or your savings account. If that child gets into a lawsuit and the creditor wins, or the other side wins, they'll go after that child's assets, and that child owns your savings account, because that's what joint tenancy means. It's theirs. And you don't really mean it that way. You mean that they get it when you're gone. But that's a payable on death. You really don't want somebody on your checking account, savings account, who could possibly have a creditor trying to cause them problems or needing the relief of bankruptcy. You want things clear. And if anybody has debt problems, if anybody who doesn't, let's go with it, it's important to think about all these things and get some good advice before you take bankruptcy, because bankruptcy is one of the great humane laws that was passed in our country, like Social Security, and they're trying to do away with it. But it's a way to get a fresh start. Our country is based on the idea that we want people to take chances, we want people to make investments, and we want them to start over. We don't want them in a Dickinson debt prison, which is horrible for them, their family, and society. We want people to get a fresh start, but they have to do certain things to earn it. And so on things that we're talking about, if you have debt problems and you're trying to restructure, there's a lot of good work that can be done to help you or your friends or your children or somebody's in that situation. One of which is don't have them be on your joint tenancy on your savings account. Yeah, Ann.
What is probate? That means it goes over to the law, is it?
Probate is a separate court within the legal court systems in America, and it's usually a different judge. You know, you have your municipal judge, your probate judge, and your like district court judge, depending on what state. And probate only really has to do with conservatorships, people who need to have their property and their person taken care of because they're disabled, or the transition of the person's property upon their death to their heirs or to their descendants. So probate is that area of the law, and it's the court that administers that area of the law. Yes, let's get...
One more question about, I have put my youngest daughter on my checking account for the very reason that she doesn't have a lot of money, neither do I. But you know, if she were to come here with her older sister, then they would have money to work with and live with.
Let me repeat that question, and then we can add modifications, because it's a really good one. And I realize that in my kind of eagerness to respond to specific questions, I often forget other circumstances which would make my answers wrong. That's the reason that this is always you need to see what parts of this may work for you, discuss it further with me if you think I didn't say it right, or with anybody who knows. Your question is basically that you have a younger daughter who it's helpful to her to be on your checking account. You want when she and maybe her older sister come here or around here, they would be able to draw on that account, live out of the same household. And I think it's completely appropriate. I think there are lots of times that you want to have that sort of thing because it's convenient. And when I say you don't want to do that sort of thing because maybe there's a lawsuit and all that, those are the real rare things compared with families working together. And basically, as you said, there wasn't much in there anyway. It's not, what you have is for your daughter anyway, right?
For both of them.
Absolutely, for your daughters.
Yeah, right.
And it's just a very convenient way to do it. You want them to have access to it now if they need it.
Yeah, because if they were to come here, if something had happened to me.
Yes. And that's another good reason. Now, what you're saying is something had happened to you or you became disabled, you've already got it set up so they can get money out of your account to meet your expenses. That's a good reason for doing it too. It's, in most instances, better, in my opinion, to have also, at least also, a power of attorney. So they not only can get into your checking account, but they can actually write your, do everything for you. You know.
Well, my partner and my daughters are both on the power of attorney.
So you have that already.
So I'm covering everybody.
That's the right thing.
They can do what they need.
Right. Your partner and your daughters are on there, so it's all set up. And most of the time, these sort of things can be taken care of really simply. You don't need complex documents. And we're fortunate in our community because we have so many also neighborhood groups that work with people. So I think that's fine. I didn't mean to suggest it wasn't a good idea.
It really frightened me, because I was like, oh no.
Yeah, well, and that's Anne had a question. You want to bring that up again? Same way. Things I say trigger, oh my. But maybe you did it right and I was talking about something other than your circumstance. So don't just take it as gospel. Thank you. Yeah, thank you for asking, clarifying. Anne?
I have a will, and thank you for this talk today because it reminded me my ex-husband is first on it, and then my children. So if I make a will now, will that override? Can I make a will saying that all other wills are no good? Or?
Yes. In all of the wills that I've ever seen, and I'm sure you can do it without doing this, but it's wrong to not make it clear that this will supersedes all former wills and revokes all former wills. And that would be effective, as far as I know, for every will. Every state has a uniform covenant to respect other states' wills. Now, your first will is in Ireland, still in Ireland, and it's conceivable to me that that could be a little more complex. So in addition to doing a new will, I would call your former husband and ask him to go and get that and tear it up. He'll know it's no longer applicable, but it can become very, very complicated. Judy was talking about 7 years of litigation over something that should have never even gotten to court, so it's better that way.
So if you have a payable on death on account, does that mean that that money is automatically going to go to that person? And I mean, I guess I say, can you override that in a will, or can you not put something in a will because it's automatically going to go to that person?
It's a perfect question. A will does not override any contract, any payable on death, any beneficiary designation, any joint tenancy. Those are all things that happen automatically, and consequently that property never goes in to be controlled by your will. So if you don't like the way the payable on death is reading now, then you need to revoke it, get it back from the bank or whatever, and set it up the way you want. Anne?
I was just going to talk about the tax implications for the people receiving property or money, but that I presume we would cover under trusts.
Well, just talk a little bit now about tax implications. Income tax are a terrific burden and all that, but we just have to figure, that's a whole different subject. But in terms of death taxes, because the 1% controls, but we get the benefit of it in this instance, as of now, you can pass 5,340,000 or something like that. So give $1 million to me, give $1 million to Sarah, whatever. So when I started practicing law, $70,000 or $700,000 was the level at which federal estate tax jumped in. And if you had a farm, because I was in central Kansas, it meant you had to sell the farm in order to pay the taxes, which was a huge and terrible burden. Now they've lifted it up every year. But because we're so far in debt in the United States, and our taxes have been so suppressed in terms of the rich managing to control that, there's a good reason to think that taxes of all sorts will go up. So it's not that you don't need to worry, but at least at this point for the foreseeable future, death taxes are really not the issue that they used to be. Over $5 million goes tax-free. That's a unified gift and death tax or estate tax, which that means you can give anybody $14,000 a year without having to pay gift tax. Have you ever noticed they want to tax you on everything? The food you buy, the gas, everything. There's a tax on giving people things. If you give somebody more than $14,000 in a year, you don't necessarily have to pay tax, but it's subject to tax, and you have to file a tax return, gift tax return. What happens is, to the extent that it's more than $14,000, it gets unified with your, as if you owned that still at your death. So if you have, $5 million and you've given away $400,000 above the gift tax, then you could possibly have a tax. It's not a serious thing, except you do kind of need to know about there is a gift tax. For state tax also normally applies, like in Kansas. There's an inheritance tax, but in Colorado, the internet said there wasn't at this point either a state or an inheritance tax in Colorado. So we're not worried in this conversation about death taxes. Yeah.
Well, I guess my question is, I own nothing, I have no property, I have nothing of value.
Simple.
That's the way I want it.
Absolutely.
So when I die, I've written my own will, which is mainly instructions. I don't, in my situation, I do not see any reason for me to have to go to a lawyer.
Yeah.
I figured I'd have it witnessed, have it notarized, and it's a done deal. There's nothing to probate. I mean,
Yeah.
there's nothing of value.
Right. Yeah. Your basic comment and summary is that you don't have anything you're worried about having it probated. You have written a letter instructing the people around you, your friends, your loved ones, what you want to have done, and you're intending to get it notarized so it's clear that this was a serious document. And is that enough? I would be completely comfortable with that. I don't, I don't think that you have to go to, there is no law saying you need to go to a lawyer. I mean, I'm kind of hesitant, when you go to the doctor and you say, I have a toothache, and he wants to look at your whole face and check your ears. Well, there's a good reason for that. There may be something that's going on with you that you don't know about. But based on what you've told me, if it were me, I'd be comfortable with that.
I have a second question. I don't know, you might not know about this. Social Security. I was told that, let's say you get your, it's direct deposited. It's deposited in your checking account, and 2 weeks later you die. They want it all back.
Well, she's asking about this. Do you owe some money back to Social Security from their automatic deposit if you die 2 weeks after the deposit? And in my experience, 25 years ago, we always had to get a little something and send back. It's like they pay you forward, so you didn't use the second half of that month. It's not they'd get it all back, but there is some provision for a refund. And people always ought to look. I mean, there's strange things. You go and fly, and sometimes just because you got scared, you bought the $10 in the machine and you have $100,000 worth of insurance, or you have insurance on your car that has a rider that you can get for a little life insurance, or your credit card. It's surprising. You can find that there are things that you didn't realize you have that...
I don't have any.
No, I don't either, but...
Keep it simple. I'm dead.
Yeah, and you're keeping it simple, and that's a great thing. Actually, it's a very great thing.
So everything that I own, I've made it very clearly I want it to be given to my two daughters whom I love equally.
Right.
Do they still have to go through probate?
Everything she owns, she wants given after her death to her two daughters equally. You need to go through probate. If there's something that that hasn't otherwise made arrangements for, like if you have a car and it's not in their names, then I don't think you really have to go to probate. I think that there are affidavits of death and estate value you can file that show the motor vehicle division that it wasn't necessary, that there was no tax to be paid, and that you can also then file affidavits of indemnification, which means that the girls say that if there are any debts related to this car, they'll pay it. That probably won't come up, but when I was practicing law, things like that happen, and I figured where there's a will, there's a way. Yeah. We figured out how to get things transferred without going to probate. But technically, if you have property that isn't otherwise disposed of by being joint tenancy or payable on death or something like that, you could end up going to probate, but probably not. Not if it's a very simple situation. And an attorney, a power of attorney is a really good thing, because if mom gets, I've had this situation, mom's sick, she's not going to recover, let's clear everything up right now. Have the attorney, the agent, the attorney in fact, the person you've appointed, might be the girls, probably, or the partner or whoever, sell the car so you don't have a title problem, then you've got the cash. Or transfer the car to the girls, and then the title's in their name.
Okay, so transfer it now.
Right.
Okay.
Not now, but if you got to the place where you thought that you wouldn't be able to drive it again.
Oh, okay.
Yeah.
But we never know.
You never know.
Today we can, tomorrow.
That's right. That's what, if you do nothing, you get caught unaware.
Yeah, and you could also be hit on the road by another car.
Exactly.
And then,
that's right.
Yeah, right. Yeah.
But if you have that attorney, and if you have that power of attorney, even if mom died last night, they'll probably accept the transfer. Technically, powers of attorney expire on the death of the principal, the person who set it up. So in theory, they need to do it, but at midnight that night,
I would have to do that.
or Mom, hang on, got another 10 minutes here, we're going to transfer the car.
So the house is jointly deeded to myself and my spouse, then that doesn't come under the purview of a will or probate or anything.
You're correct. If it's already in joint tenancy between the two of you, it's not controlled by will, it doesn't need to be probated. It's already hers.
Could you repeat the question?
If their home is in his name and in his spouse's name, and then he dies, will the probate court have to get involved in order to transfer it? No. It's already owned by the spouse. What joint tenancy means is you both own it right now, and whoever survives still owns it. So at that point, you'll no longer be an owner, but you're no longer needed. It's then your spouse's.
Well, can you be joint tenants in common?
Tenants in common, at least in Kansas, is a different title.
Right.
And that's, generally we would use that where we were worrying about estate planning. We were trying to keep both estates lower back when it was a much less threshold and estate taxes were an issue. Tenant in common means you own half, Dennis owns half. If you die, he doesn't get your half unless you have another way to get it to him.
That's my next question.
Yeah. You want it in joint if you want it to just automatically be the survivors. Can't see many reasons to use tenants in common anymore. It used to be quite common.
An investment property, I think.
Yeah. Yeah, and when you start talking about investment property, there's different issues. Jan?
So if you have accounts that are not payable on death, and you itemize them out in your will, that will still have to go through probate, unless it maybe you meet some of the things that you were telling her about.
Yeah, things that aren't otherwise disposed of really do end up going through probate unless you have a clever lawyer or friend who knows how to do these affidavits. And you can go to, in small towns, it's amazing what you can do in terms of just talking to county clerks or whatever. People want to help. People don't want you to have extra expense. And in Kansas at least, and I think probably in Colorado, they have new things that are simplified probate proceedings. People, and we all have horror stories, like Judy was talking about, of people who've gotten into conflict and been in probate court for years. But actually, in most instances, it's a lot simpler than it used to be, a lot less expense. Lawyers used to, the traditional thing with lawyers, and this may be when your own parents died, it was the way it was in Kansas in small agricultural community. Lawyers hardly ever charged anybody anything until they died. And then they had big fees, 3%, 4% of the estate. And that's how they finally made the, and if other than the big time shark lawyers, just like the hedge funds that are making millions of dollars, the majority of lawyers aren't making a lot of money. They're like every other person in town that's making a living. And they no longer do they make a percentage charge for catching up when the person dies. At least in Kansas, under the ethical provisions and everything, lawyers now charge the number of hours rather than a percentage of the estate. So it's not as concerning as it once was in terms of probate being so expensive. People have memories from what other people went through that probate's terribly expensive, but particularly when you have a will and a fairly simple estate, the accounting part of it's not hard. The court fees are 2%, something like that, or maybe even less. I don't know, but it's not something to be dreaded if you do your thinking and your organizing in advance. But as I said, usually you'll be able to avoid probate by making other arrangements if your estate's fairly simple, or if you have a trust. So we should talk a little bit about trust.
Yes, that's what was my question. When would you know that you need to get a trust? I mean, If you have a will and you say, well, half goes here, half goes there, you know, why
Well,
would you want a trust?
That's right, and that's kind of why I had made a mental note before this to say, don't be afraid of probate. People think they're going to have all this terrible expense with probate. If you have a simple will and an honest lawyer and a good judge, and there's no reason not to be able to choose an honest lawyer and find a good judge. I don't think it's that hard. And then you know it's going to happen the way you want it. So, but if you have a more complicated thing, you might want to have a trust. And this is really for people with more of an estate, more that they're concerned about. One reason people don't like probate is that you have to file an inventory of what you owned, what your business was. If you're you feel that's personal, as I do, ideally, then you need to avoid probate, because probate is public records. And one way to do that is you have your property owned by a trust, because the trust already exists. And the fact that you died, the trust goes on, and your trustee does what you would have told your executor to do in a will. In other words, it's a private will. It's a private arrangement. It's an instrument that manages your property while you're alive if you want it to, or if you become disabled, and at your death distributes your property the way a probate court would, and you never have to file an inventory or otherwise advise the public of your private business. Now, most people don't worry about it, and I don't think it's a big thing, but that is often the reason people, particularly people with bigger estates and complicated affairs, like to have trusts. Or if you have investment property and you just, you know, it's your business. Okay, different kinds of trusts. And trust is, thinking of it, you're trusting somebody to operate for you. That's where the term comes from. And there's all kinds of general law, equity law that I've talked about, that if that trustee is just conniving and self-dealing and some friend finds out about it, you can apply to a court and the court would remove them, punish them, whatever, however severe it is. So it's not like you're actually putting all of your faith in this person continuing to be a good person. But to say the least, you don't want to entrust anybody that you don't trust. And you don't want to set up somebody to be a trustee or an executor in an estate or a guardian of your child without talking about it, because they may say, there's no way, I'm hardly keeping up with what I have to do. I love you, but I can't take it on. So you have to have a heart-to-heart with people. And I want to say one thing so you understand, because it's even complicated to think about myself. Well, if I put everything in a trust and that trustee, well, I want to operate my own property. I don't want them to. If you make it a revocable trust, which means you can revoke it and change it anytime, you always make yourself the trustee. You don't make somebody else a trustee as long as you're able to handle it. So you can be both the trustor, the person who establishes the trust, and the trustee. You are going to operate it for your own benefit. And in fact, if it's revocable, you don't need to have the trust named. You transfer your bank account to the trust, but it still just shows on the account as yourself, and on the account ownership it shows owned by the Jay Bremyer Trust or whatever it is. But it just, as far as the public knows, it's just you. You actually transfer, ideally, if you're trying to avoid probate, everything that isn't otherwise disposed of. So if you have business properties or whatever, you actually transfer investments, IRAs, whatever it is, you put them in the trust. That's the basic concept. I can go on and on about it if anybody really is interested in the details.
Can one do it oneself? Are there forms that you can download?
Absolutely, yeah. On this Rocket Law thing, there was like 10 different kinds of trusts you could download and fill them out yourself, and then it says you can check with these lawyers that are affiliated with the deal, so you haven't done anything wrong. Jan's in back. Jan?
Oh, and is there kind of a ballpark of a minimum out of your estate, if you have that much, you should start looking at a trust real seriously instead of just leaving it in the will, or is that?
I don't know that there's a ballpark. It's more, for me, the reason is just whenever you feel comfortable and you know, there is some more bookkeeping, there are new sets of deeds that need to be made of your home to the trust, and you should still have a will, obviously, and in will what you say is all my property goes to the trust. So it's very simple will, but just in case something didn't get transferred to it. In addition to the property and tax issues on trusts, another good reason to do it is because you want to make provisions for kids and grandkids, and you want to have established who's going to be the one that operates after you, which is usually a younger brother, sister, maybe you have a kid that's already grown up and that's an accountant, and they have kids. You know, your kids can get hurt or disabled, and in that case you want your grandkids to get the benefit of what you've put together. So you think of all these more elaborate things that you want to plan for, and the best instrument to take care of that sort of thing is a trust, because it's private, because you have all kinds of alternative things you can do in it, and I'd say those are the main reasons. Yeah, it can in certain instances. The revocable trust, which is what I'm talking about, because I've never felt comfortable saying that I want to give up control as long as I'm able, because things change. But if it's revocable, it means it's still yours. And so it may help a little bit because people may not know what you own, but if you actually get in a lawsuit and a creditor's coming after you under oath, you have to reveal everything or go to jail. So it really isn't ultimately. If you're doing that kind of planning, what you want to have is an irrevocable trust and put those assets in it that you're trying to shelter from a creditor. Yeah, and those are very, they're online too. You can look that up and see about that sort of thing, or call and we'll visit. Well, what she was asking was whether or not having property in a trust would help to shelter it from creditor attacks or otherwise getting entangled in your affairs. And my answer is, as long as it's a revocable trust, it's still you. You're really just simply trying to set something up so if you become disabled, you don't need to have to rely on the power of attorney person who has more limited authority. Your trustee will have all the authority that you outline in that trust, and the trust will manage your property.
Do you understand, though, if you call yourself, you are the trustee, you're able to name someone in case that trustee...
Absolutely. You always have a successor. Absolutely. Yes, that's what I meant.
Okay.
So, if I would like to change my will now, can I get a form from the internet?
Yes.
In Colorado, what do I need? I need 2 witnesses and notarized?
Right.
Is that it?
Yes, but you know, I haven't gone and looked. I think I have some examples in here, but the people who left took all of our forms. But on any of those sites, they'll have Colorado wills, and it'll show you exactly how many witnesses you have to have. And it seems to me like there's a 3rd page, which is a declaration page in Colorado, where the witnesses say they were all there and saw each other see you sign your will. So it's a little more complicated. Kansas is very sweet that way. We have an old case by Justice Black in 1880, and he said, I don't care whether it was written on the side of a cow. If it was written, it's good enough for me. But I didn't find anything like that in Colorado.
So there's not, somehow I had in my mind with a holographic will, all you need is a pencil and paper and date it and sign it, and there are ways to verify your signature, and that's it.
That's the definition in general of holographic will, the way I remember it. But in Colorado, from what all I looked at was examples at this service site, and they all, and I know you're better off to follow the details. And it just eliminates the possibility. There may be old cases like in Kansas where some judge said, I don't care, I'm going to do it. But that's kind of when equity comes in, and most judges these days are more concerned with the protocol of doing it according to the strict letter of the law.
Because you sign other things that
Yeah. Yeah.
without notaries and witnesses and. But I see what you're saying. There's no use to rock the boat if you don't need to.
Yes, I'd err on the side of caution on something as important as that. But I always also think it's very good to have letters to people who are going to be involved, really saying what you meant. And in my experience, families that have worked together figure out how to really do what dad or mom or whoever meant.
So if you don't name an executor, if the will does not name an executor, then the state, the
Probate
county court or whatever appoints there's a court-appointed lawyer that does that, or how does that?
It'll generally, in my experience, will be a lawyer. It not only happens like that you didn't name an executor in your will, but oftentimes you name somebody who's no longer alive or not available, and the court will appoint an administrator of the will.
So is that, so if it's a simple will, is that terrible? Does that turn out to be, if the will is properly done and it's a simple will, does that turn out to be terribly expensive in the court?
Not in my experience. Based on, there's been a real effort from the kind of the consumer community, the regular citizens, to cut down on the expense of probate. As a result of that, they have the simplified probate laws, where a lot of the old routine and the protocol is simplified, and it makes it less expensive. I think on something as important as your final decisions and testament, that it's worth having a will that's available. If people can just follow, I mean, we've had situations like you were talking about where the property was simple enough, we said it was not even necessary to probate this will because we can get it all transferred and we'll just follow the instructions of the will without ever doing anything. What I do in that instance, because there's a duty on the part of people who have a will to offer to probate, otherwise Judy wanted to give me all her stuff. I was just sure of it. And when I read her will, it didn't say that, so I tore the will up. So you don't want to not file a will with the court, but you can file a will with the court and ask it not to be probated. But then it's off your chest. It's there if anybody ever wants to check it. But then you and the survivors do what the will said anyway without any expense.
To say that again, so if you write your own will now and you have signatures and then you make that part of the will saying, I don't want this my property to be probated.
Okay. She's asking whether if I meant that you can have a will where you say everything you want and then add a provision saying, but I don't want this to be given to the court. Mm-hmm. No, you can't. I'm just saying that if your daughters and your partner know what you want, you have a will, and they look at it and they say, we can get this all done without having the expense of a lawyer and a probate court. They can take the will and give it to the probate court so they're never accused of doing the wrong thing and say, please don't probate this. I'm just filing it with the court so it's a record.
Okay, great. Thank you. That's very helpful.
Yeah.
Yeah.
Jen?
What are the things that you would want to look at and consider in choosing an executor, or trustee, and a lawyer?
What do you want to look at in choosing an executor, a trustee, a lawyer, or a guardian if you still have minor or dependent children? You want to look at who's trustworthy. You really want to look who's competent. There are lawyers that you could really admire as people, but you know, their expertise is in divorces or is in criminal law, and they're not necessarily going to be a good lawyer for you to appoint to help work with your will or your estate. So you want to usually get, I always like in dealing with lawyers or accountants to try and find somebody who's been down that path and ask that you know, and ask them, what was your experience with that lawyer? There's also Martindale-Hubbell, which is an absolutely credible, independent, objective evaluation system for lawyers. You can go online, any lawyer is going to be rated. And just because it's basically, if they have a V, it means they're they have good ethics, and if they have no V, you wonder about that. And otherwise it's C, B, and A. And C lawyers, just because they're C lawyers doesn't mean they're bad lawyers. It could be a young lawyer. You work your way up. You know, you don't start at an A. You got 20 years or something before you get a chance at that. But if the lawyer's been practicing for several years, I'd like to find a lawyer with B, if I could, unless I knew him. If I knew him or her and I knew they're good people and I trust them, I wouldn't worry about any outside evaluation. But if I was looking for a lawyer in Seattle, or sometimes I have to do that sort of thing, I don't live there, I don't really have a friend there, I'll start with something like that.
And what was the name of that?
Martindale Hubble.
And when would it be advisable to use a lawyer as your executor? So like I don't have any children, so that's, and none of my other relatives are close by, so my husband. So this is where I'm wondering, do I pick somebody in the family who's far away, or use
That's a common question. When do you consider using your lawyer as an executor, particularly in a circumstance where you don't have any immediate relatives or close people that you feel like you would rely on to do that, or you would ask to do that? Because when you ask, you're asking something. And I should add, just so you know, in general, if somebody has been appointed as a trustee or an executor or whatever, and they anticipate it being minimum expense, but they get into a lawsuit, your estate gets sued, or the trust gets sued, or a kid's gone missing, anyway, there's a lot to do that wasn't anticipated. The court will arrange for them to be reimbursed or taken care of. And usually in a trust or a will, it'll also make provision for paying reasonable expenses and fees. If that weren't the law, nobody in their right mind would ever agree to take on that responsibility, because they could spend their life fighting somebody else's problems and have a duty to do it but never get paid. Most instances, most family members, most close friends keep their fees at a minimum, because they're doing it because they're doing it because you trusted them, because they're a person worthy of trust, and not to get money from you. But those are part of the things you evaluate. Is this the kind of person that I trust in all dimensions? Not just that they're competent, but have they done nasty things to other people when they weren't looking? You don't want that person. Now, your question was, should I have a lawyer? He's helped me or she's helped me with my will. Is that a good person to name as a executor? It used to be pretty common, and I would ask that lawyer whether that would be a good idea. I would discuss this with the lawyer. It could be in certain states they don't let the lawyer do that. They say that's a separate function, like in real estate. You know, you can't be on. There's all kinds of rules that may apply that I don't know about. I myself, when I was writing wills and trusts and everything, I did not ever want to be that person. I wanted to have an independent responsibility to be the lawyer and to advise if I was needed. But
could you get a different lawyer as your executor?
Yeah, and you know, banks have trust departments. People oftentimes will, they've worked with a bank for a long time, and they have a banker they trust, and the bank will have a bond, be certified like a title company, so that if anything goes wrong, there's that reimbursement. So that's a possibility too. Yeah, it would be somebody in the trust department of a bank. Or the banker is a person you believe and care about and trust, and he or she would take it on as an individual function, not as a part of the bank. Yeah.
Quick question. Isn't the executor of an estate entitled to 3%?
Isn't the executor of an estate entitled to 3%? I don't know whether there's any rule like that in Colorado. There used to be customs as far as what the court would allow. And the 3% wouldn't surprise me. But again, that depends. If it's a simplified probate where they've done hardly anything, I can't quite see how a court would feel that's appropriate. If it's a complex probate with lots of property and they had to spend many, many hours, then 3% might be awarded. But I don't know what the law is or regulation or custom is now. Yeah.
If there's, if spouses die simultaneously, then joint ownership is out the window, obviously. So do most wills among spouses address the disposition of their estate, of their property, in the event that they're both scraped off the pavement or whatever?
The question is often asked, what will happen if there's a simultaneous death? And the spouses, in this instance, in this example, are joint tenants on property. Who died last? And those are classic. There are lawsuits about that sort of thing where no provision was made. My dad had one that went to the Supreme Court. A couple were on a farm, and the tornado came along outside of McPherson, wiped out the farmhouse, killed the parents, her parents. They didn't know who died first or second. There were children by different marriages, so who inherited? The wills that I looked at in Colorado on that rocket service all had a section for saying what your decision is in regard to simultaneous death. All trusts that I've ever seen talk about that too. For that reason, you need to decide.
Or even deaths that happen within 2 weeks of each other, or whatever.
Exactly.
It's the last one alive, right?
Yeah, that's if you don't otherwise say. And sometimes you'll have something they'll say, it all depends on who ultimately is inheriting. If you only have the same children in common, but then if you have children by different marriages, it really becomes something to say. And you might say, if it was your intention, that if we die as a result of the same accident, or within 6 months of each other, or whatever it is you decide, we still, nevertheless, want whatever property remains to be divided equally between children of the first married, children, you know, whatever, or per capita. There's terms that you'll see as you look at these forms. They'll often say property descends per stirpes, and per stirpes means, according to the roots, it means if a child dies leaving grandchildren, the grandchildren take the child's share. Per capita means everybody who's a descendant from me, all my linear descendants, each take according to the heads per capita. So the grandchildren would come in and take the same share as their uncle and aunt. Most people say, no, I really intend it to be, they take their parents' share. My son has 2 kids, my daughter has no kids, my other son has 3 kids. That's kind of a difficult example, but if the son dies leaving 2 kids, his 2 kids just get his share. That's per stirpes.
So there are joints. It's not, is it common for spouses who have a joint to have one will that they both sign?
It's not common, but I have seen them. It's more common to have wills they do at the same time that are carefully coordinated, that take into account those things. There are some joint wills on the internet, though, to look at. It is valid. Well, if it's in those, if it's in one of those rocket forms that they have prepared for Colorado, it means they're valid.
What's the best way to store a will? Like if you make out a will, how do you keep it safe so that when you do depart, that it's somewhere safe where people can access it?
How do you keep your will safe so that it will be the one that's found and used in the time of your death? Everybody has to make their own decision about that. If you have a law office do it, oftentimes the law firm will keep it, and they will keep track of deaths and have a responsibility. I mean, they have a burden to keep those and to make it available to the court. Another thing about wills or any probate proceedings, and there may be a way to do it in Colorado, is once you die, what happens as far as creditors who you still owe money to if there's no provision made. And you want to cut those off eventually. You don't want to just have people hanging out there for 5 years and coming and claiming a claim against your kids that got your property or something. So there's provisions for filing notice to creditors in the newspaper, and then it says file your claim by such and such a date. If they don't, then they're basically your kids and can go on without worrying about it. And your will is a very important document, and you want to have it in a safety deposit box where it won't burn, won't be lost. Even if it's a safety deposit box in your home, just something that's fireproof. And you want the people you trust to know where it is.
And is the will, the actual copy of the will, a copy of the copy of the will won't work for?
And there are instances, at least in case law, where they can't find the original of the will, but somebody has a copy and they offer it to probate, and they have to prove to the satisfaction of the court that this in fact is an authentic reflection of the will. I don't know whether that can be done in Colorado, but it's been done in Kansas, I think. But it's like we were talking, you want to be more cautious. You don't want to rely on something that's not pristine and clearly the last will.
You can file you were talking about filing the will with the court, right?
Yeah. Well, I'm talking about after you're dead.
No, right. But as far as having the fireproof box and this, that, and the other, once you get your will the way you want it, you take it to Saguache and file it with the court. Right?
There may be a provision to do that.
Can't do that?
I don't know. Do you?
No.
The question is whether, does anybody know whether there's a provision in Colorado where you can take your will to the court in your county seat?
You did.
Did you? Is that where you took yours to Alamosa?
It's in their safe.
In Alamosa or
Saguache.
Oh, I thought you said Alamosa.
No,
That's what confused me. If it was your
Saguache.
will, this means that apparently you can in Colorado.
So it's not public record.
It's in their safe.
It's just
I don't know how.
They took it, it's a sealed envelope, and it's...
So it's apparently not accessible to somebody snooping around. It's just categorized under the name of the testator. And so just call over there and see if they'll do that. That's a good way to do it. Of course, like we were talking about, you've moved to America and you've just, in this discussion, remember I had a will in Ireland. You can move out of Saguache and you just have to, I think checklists are very important, where if you have a calendar that you use every year, you know, a day book or whatever, put it in the front of there, put it on your computer if you have some program that way, and on there say, you know, check will, check, you know, those things that you think that we've talked about here today, as well as other things that you think are important, and then just get in the routine. Let's have a system where once a year you check that, and you'll be amazed at the things, I'm amazed at the things I forget.
You forgot, did you remember?
I remember we did it a long time ago.
Yeah.
It probably isn't what we want now.
Right, well, it's worth checking.
Right, let's get it back.
Yeah. Well, it's before Jonathan.
Yeah, oh yeah.
Okay.
I just want to share that when my parents passed, when my father passed, he had sent me, I was the executor of his will, or my parents, and it was in a trust, and there were 4 siblings, and I was appointed the executor, and it was real simple. You know, there was a stock account, a bank account, a vehicle, the house. I never had to even call the court or was contacted by the court.
Yeah.
It was real simple.
Right.
I mean,
and
I had to show power of attorney for where he had accounts.
Yeah.
And that was it.
Yeah.
The money came,
yeah.
Wrote checks to my siblings, and it was all over.
It was very easy.
That is exactly the beauty of having thought it through like your folks did. And what has often been a nightmare that we all dread in terms of our folks or whoever going before us can be very smooth and very inexpensive. As in the case of Dennis's saying that his parents had it all set up. So as executor, there was not, he didn't even have to get entangled with the court. Right. Just follow the rules, distribute the property. Yeah. People feel so much better that way.
I have a question. The people inheriting whatever the property is or not, say our children, they will be taxed on that?
No, that's called inheritance tax. Kansas has an inheritance tax. Federal estate tax is tax on the privilege of owning property, like that you had at your death. It's the on the property, like on your house. Inheritance tax is what you get taxed for your share that you receive. There's no inheritance tax in Colorado. There's no federal inheritance tax. Inheritance tax isn't very much in Kansas because there's big exemptions for spouses and children, but it can be quite a bit if it's somebody outside of that linear descent that's inheriting, because it's not an inheritance in the sense of intestate, it's you willed it to go to them. So that's a different thing. That's a good example. What you're saying is, if you own a piece of property in joint tenancy with another person, and you die first, and then they die before they can take possession, or before it really becomes theirs. Well, the fact is they already own it if it's in joint tenancy. So if they die after you, in the absence of a provision in a, but if it's in joint tenancy, the provision wouldn't matter in a will because they already own it. It will go to their, if they have a will, it'll go under their will.
If they don't have a will.
Then it'll go to their descendants.
If they don't have any.
No, okay, there are provisions where it cheats to the state. There's a huge amount of money that no heirs ever showed up to inherit, and it's being held by the Secretary of State or the Treasury of states all over the country. And that's what happens to it. And it's a shame.
There's no end to how many people you have to put in there.
Oh, yeah, it's true.
Yeah, you have to, these things are all important. The 5 steps that you mentioned, the end of life, and the preparation for the event of disability, those are the key things for all of us to think about. It makes them so much better, not only for ourselves, but for those who we love who have to deal with it. So I really thank you for all coming. I really want to emphasize again. Call me.
Thank you.
Watch that sword. You're amazing.